So today we have joining us Senior Advocate Gopal Sankaranarayanan, who had appeared before the five-judge constitution bench that had in March this year given its verdict regarding the appointments to the Election Commission. So now the government has introduced a new law that has put in place a selection committee comprising of the PM, a cabinet minister, and the leader of the opposition in the Lok Sabha to appoint the chief election commission as well as the election commissioners. Your first thought on this?
Well, I believe on first blush, from what I understand and having heard of the bill, I think it's just a sudden measure to subvert the impact of the Supreme Court's judgment. The Supreme Court, in fact, frowned at the fact that for 73 years they hadn't bothered bringing a law in. No government, no party had bothered bringing it in because they wanted the executive to control everything. So now suddenly waking up to bring a law in seems extremely odd, to say the least.
The Supreme Court, throughout its judgment, had also mentioned categorically about why there is a need for the election commission appointments to be done by an independent body. And they'd also
Yes.
gone to the extent of saying that a new law that is brought in should ensure that the entire power does not rest with the executive, which is exactly what the center has done through this new bill. So, do you think this negates the Supreme Court Constitution Bench judgment?
100%. But I'm not remotely surprised because the government has been doing this incessantly over the last 2 or 3 years. Every time a judgment comes which is not palatable to them, rather than implement it by virtue of Article 144 of the Constitution, they will bring an ordinance, they will bring a law, they bring a bill, they try and do something or other to subvert it. They did it yesterday by passing the uh, bill with reference to the Delhi government and the services issue to get around a constitution bench. They're doing it today to try and get around another constitution bench by bringing in another bill, both of which are direct negations of what had to be done.
In fact, if I remember correctly, the center had also argued before the Supreme Court that there was no lacuna at all. There was no void to be filled by Supreme Court's intervention in this matter. And soon after the Supreme Court judgment, they've now brought in a new law that still till now, for the past 70 years, had not been brought in by any government. What do you think has ignited this sort of a hurry for the center to bring about these changes and how the appointments are done? Especially when an interim measure was put in place by the Supreme Court. It's not like there was something missing.
Well, the one immediate message one gets from this is that discomfiture with having the Chief Justice or the Chief Justice's nominee as the third member in that committee, along with the Prime Minister and the leader of the opposition. Clearly, they want their choices to go through. They want to control it. They want to have the majority in this, and they find the representative of the judiciary as someone who will be clearly independent. It's definitely also a good sign about how independent our judiciary is, and makes it clear that the executive realizes that, and they will go to the extent of bringing an entire bill in to try and sidestep it. The judgment is extremely clear. They devoted several hundred paragraphs to the fact that the executive having any control over this was, and this is the words that they've used specifically in para 227, that it's a stopgap arrangement, and it was to be replaced by a law by the parliament, taking away the exclusive power of the executive. They say that that conclusion is inevitable, and there was no question. Once 5 judges of the Supreme Court and the Constitution bench have given you that decision, for them to be trying to subvert it and get around like this, it's quite surprising. They just think because they have the power of parliament, they can. I'll find it very difficult to see how it can pass muster.
If this is challenged before the Supreme Court, which the chances are that it will be, what do you think the chances of it being stayed are, and ultimately the Supreme Court deciding that this goes completely contrary to what the 5 judges had ruled?
I will follow the same measure that I use when clients and instructing solicitors ask me for chances of cases, which are I don't know. I believe that it's a glaring error. I believe there should be no question. It should be stayed for the asking. But whether that will happen, whether in fact, the Supreme Court will come down heavily like a ton of bricks, like it should? I don't know. I can't answer that.